Good afternoon. It is afternoon, and happy Halloween. Welcome. I am Sharon Eisman, and along with my co-chair, Elizabeth Wells, the Joint Task Force of the CBA and the Women's Bar welcomes you to this program. And I see that our president is here, the Women's Bar president is with us today. So thank you for that. We also want to thank, for a quick moment, the co-sponsors of this program, whose support and contributions we are grateful for, and that includes besides the CBA itself and the Women's Bar, the ABA's Commission on Women in the Profession, the CBA's Alliance for Women, the ISBA's Women in the Law Committee, and the Young Lawyers Division of the CBA. And I have some housekeeping items I need to read to you. First, please turn off your cell phones. And secondly, for those who are attending in person, when you registered, your attendance here has been recorded. If you need MCLE credit from another state, you need to check in after the program at the registration table. And then also important is to explain Adria Mossing just walked in. I introduced you before you came. I will introduce the person who will be moderating the program, but I first thought I would tell you what the format is. It's a 2-hour program. The first hour will be presentations from our individual panelists, and then they will serve on a panel, and Larry will moderate that with questions based upon what they communicated to you and issues of the substantive, legal, and societal concerns. And so in the second part of the panel, we will leave some time at the end, hopefully about 10 to 15 minutes, for questions from the audience. When you're checked in, those of you who are attending in person, you received an index card. It doesn't mean you have to write a question, but that's the way that we'll communicate it today. You can ignore the microphone in the middle of the room. We won't be using it. It's much easier to read the questions from your cards. So as you're going through and thinking about issues raised during the seminar, feel free to write your questions down, and we will be collecting them as you write them and they're available. And then I would like to introduce Larry Suffredin. He's to my immediate right. For some, he needs no introduction. He's well known in the CBA because he is our legislative lobbyist, and he is also widely known in Cook County because he serves as the Cook County Commissioner for the 13th District. I don't know how he's done all the things he listed in his resume, and I could say that about all of the speakers who are here today. They have rich backgrounds, and what? Okay, I'll start over. No, I won't. So he has recently joined the Taft Law Firm. Thank you, Elizabeth. And before that, when he was in other areas of private practice, he represented healthcare concerns, corporations, and also various entities of local government. And in addition, he was a public defender, and he served on the federal defender panel as well. And now he just has to focus on all of his work with the CBA and for his law firm. And we're grateful to have him here today. It's phenomenal to be able to capture these people who are constantly in motion to join us today. So I am now turning it over to you.
Great.
Thank you.
Sharon and Elizabeth and the other people who planned this, thank you for discussing this important subject. Let me first introduce the panel. Down at the end, Deane Beth Brown is a partner in the Chicago law firm of Hughes, Socol, Piers, Resnick, and Dim. She specializes in employment law and is someone who understands the implications of passing the ERA on the practice of law. David Franklin here is currently the Solicitor General of the state of Illinois for our Attorney General. Before that, he was a professor at DePaul University. He is a former law clerk to Ruth Bader Ginsburg, not on the D.C. Circuit, but on the Supreme Court. Am I correct?
Correct.
Yeah. And you also were a law clerk on the D.C. Circuit just before that. He's going to talk about kind of the history and an appellate lawyer's approach to how you would put together the brief arguing what's going on here with the ERA. Sitting next to him is Senator Heather Steans, who is the Senate sponsor of the ERA. Heather represents a district on the near north side of the city of Chicago, and she has a little piece of Evanston, so I get to claim that she's one of our Evanston state senators. She has been primarily the architect of appropriation reform and pension reform, anything that involves the money of the state. She has gotten involved in and been a great leader. Even though I know you sit there and say this state seems to have problems, it's not because of Heather or her trying. She has taken on a number of other issues, and one of the issues that she sees as important is sponsoring the ERA at this point. Next to her is Representative Lou Lang, who has been a panelist before in a number of CBA, CLE operations. He is a lawyer. Heather is not a lawyer. Lou is a lawyer. He is the number 3 ranking member of the Illinois House of Representatives. He has sponsored all kinds of things. I was looking at his resume. One of the most important things the General Assembly has done in the last 10 years was a major capital program. I dare to say where we'd be without that major capital program in terms of the infrastructure of Illinois. Lou was one of the architects of putting that together. He has chaired the Judiciary Committee. There's really no legal issue in the years he's been in the General Assembly that he hasn't had a hand in. I've always said that John Cullerton and Lou Lang, between them, have sponsored half the bills that have ever been introduced in the state of Illinois and half the laws because they both are just prolific. And so Lou is the House sponsor of the ERA. When I was just starting out in law school, I went to Georgetown, and there was one bookstore that every law student bought their law books at. And so I was standing in line, and there was a young woman standing in front of me. And one of the things that I bought was a 10-cent copy of the U.S. Constitution. And she said to me, well, my husband carries one of those with him. And I thought, well, that's good. I said, well, what's your husband doing? She said, he's an Associate Justice of the United States Supreme Court. It was William O. Douglas's last wife in his historic career. And about a week later, Justice Douglas came to the Georgetown Law Center and talked to the freshman class. And his subject was understanding the Constitution and understanding the difference between a Constitution and a statute book. He said, you amend statutes all the time to meet what's going on, but the Constitution should be fundamental basic rights that you are protecting and that you shouldn't be amending. So if you come to the point where you need to amend the Constitution, there has to be a serious reason for it. Now, at that point, I will say I didn't know anything about the ERA, and I was in law school well before 1972 when the Congress first passed the ERA and gave the states a period of time to ratify it. But I've since learned a little bit more about it, and it's amazing to me because when you look at the Bill of Rights, which are the first important amendments to the Constitution, they were all dealing with personal rights of people, and for whatever reason, sex and gender were totally forgotten. Now, of course, it was a Constitution that didn't allow women to vote, so maybe that was the reason that it happened. There is a woman who took on the task of trying to pass an Equal Rights Amendment. Her name was Alice Paul. And Alice Paul in 1923 proposed an amendment that was a little bit different than the language we have today. Her original amendment was this: men and women shall have equal rights throughout the United States in every place subject to its jurisdiction. Congress shall have the power to enforce this article by appropriate legislation. Now, she later amended that in 1943 with the language that we're now talking about, which says, equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. The Congress shall have the power to enforce by appropriate legislation the provisions of this article. The amendment will take effect 2 years after the date of ratification. Now, as many of you know, in 1972, we were given a period of time, and we were 3 states short. They extended it to 1982, and we were still 3 states short, though there were some states who had approved to try to undo the approval, and that becomes an interesting question. What has happened now, you say, well, since 1982, why would anybody introduce the ERA? We've come down, after a series of federal court cases, to the question of the 3-state strategy to pass the ERA. Illinois being one of the key states in this 3-state strategy. And that's what we'll be discussing today, why it's important and why constitutional protections are much better than statutory protections. So it's now my privilege to introduce David Franklin to kind of give us an overview of what the ERA is all about. David?
Thank you, Larry, and thanks to everyone for being here and to the organizers as well and for inviting me. So let's start with some basics. I'm sure you all know this, but just to get it out of the way, Article 5 of the Constitution tells us how the Constitution is to be amended. It says that proposed amendments have to be passed by 2/3 of both the House and the Senate, and then ratified by 3/4 of the states, either in state legislatures or in special conventions. As Larry alluded to, and as Justice Douglas talked about, this is not easy to do. It's not meant to be easy to do. It's probably, frankly, a little bit harder to do than it ought to be. But nonetheless, in the 2 1/4 centuries since 1791, when the Bill of Rights became part of our Constitution, the Constitution has only been amended 17 more times. So let's talk about the ERA. Larry read you its text and mentioned that it was first introduced by Alice Paul in 1923. And it really didn't go anywhere until the women's rights movement caught fire in the early 1970s. And then ERA really gained momentum. In 1971 and then in 1972, ERA passed both houses of Congress by overwhelming votes and was sent to the states. Notice, by the way, that the president has no role in the amendment process. So it's the House, the Senate, and the states. So 1972, March of 1972, ERA is sent on to the states, and within 48 hours, half a dozen states ratify it. And within just 9 months, that total has risen to 22. Then we get 8 more states ratifying in 1973, but then the pace of ratification begins to slow down. In the next 4 years, from 73 to 77, only 5 more states are added to the list, bringing the total to 35, which is where it remains to this day. Now, the magic threshold for becoming part of the Constitution is 38 states, 75% plus 1 out of 50. So the ERA has been stalled, 3 states short of the finish line for nearly 40 years. Why did the ERA ratification movement stall? Here there are 2 prominent theories. I think both of them have some plausibility. The first theory is that the women's rights movement and the ERA ratification movement in particular ended up sparking a counter-movement. Led by Phyllis Schlafly, the Stop ERA campaign emphasized traditional gender roles and tried to convince people that ERA was going to lead to unisex bathrooms and women being drafted into the military and the end of protective laws concerning alimony and child custody and a parade of many other horribles, and it seems to some extent, have worked. So that's the first theory about why the movement slowed down. The second theory as to why the amendment stalled is that at precisely the same moment that ERA was at its height, the U.S. Supreme Court finally began to use a different constitutional provision, the Equal Protection Clause, to guarantee at least some protection against official discrimination on account of sex. And not only that, but around the same time, so early 1970s, we saw the emergence of other legal protections, such as Title IX, EEOC guidelines on the application of Title VII to sex discrimination, the constitutional protection of abortion rights in Roe versus Wade, and the passage of state ERAs, such as Article 1, Section 18 of our 1970 Illinois Constitution. So it is certainly possible that the emergence of these other legal avenues to combat various forms of sex discrimination took some of the momentum out of the movement for passage of the ERA. Now, I certainly don't mean to suggest that the Supreme Court has achieved, through the Equal Protection Clause, everything that would have been achieved through an Equal Rights Amendment. That would probably be an overstatement for a couple of reasons. For one thing, as I'm sure you all know, the court has held that classifications drawn on the basis of sex are subject under equal protection to a so-called intermediate level of scrutiny, so that they can be upheld, but only if they are substantially related to the accomplishment of some important government objective. Now, it's true that the court in its equal protection case law has sometimes used stronger language, such as the exceedingly persuasive justification language from the VMI case, but nonetheless, intermediate scrutiny is official equal protection doctrine, and it's certainly quite possible that official ERA doctrine would look different and be perhaps stronger. Relatedly, I think if a majority of the court were ever to adopt the late Justice Antonin Scalia's originalist or textualist approach to constitutional interpretation, which, by the way, I don't think, for the most part, the court ever has, but if it ever were to adopt that methodology, ERA would no doubt provide a far more doctrinally secure foundation for women's rights than the Equal Protection Clause, which, after all, doesn't mention sex and is embedded in a 14th Amendment that explicitly protected the rights of male voters after the Civil War. That's in Section 2 of the 14th Amendment. Many of you probably remember some remarks that Justice Scalia made about 5 years ago where he said, you know, the 14th Amendment doesn't outlaw sex discrimination. It doesn't say anything about it. If people want to outlaw sex discrimination, they need to pass laws or constitutional amendments, one supposes. So there certainly are some things that ERA would probably do that current constitutional doctrine and current laws do not do. On this issue of the relationship between equal protection and sex discrimination, I want to take you back for a moment to a fascinating case from 1973. So this is a time when ERA is still at its apex, but on the other hand, the Supreme Court is just beginning to apply equal protection ideas to sex discrimination. It was a case called Frontiero versus Richardson. I'm sure many of you are familiar with it. It was a challenge to a federal statute that contained a presumption. And the presumption was that military wives were economically dependent on their servicemen husbands for purposes of various federal benefits. Whereas military husbands were not presumed dependent, so they had to prove dependency with respect to their servicewoman wives. This was one of the early cases that was argued in part by my former boss, Ruth Bader Ginsburg, on behalf of the ACLU Women's Rights Project as amicus curiae. Justice William J. Brennan, who, by the way, was no feminist, read the relatively recent biography by Seth Stern and Steve Repeal, he wrote an opinion in Frontiero striking down this federal statute under the equal protection component of the Fifth Amendment Due Process Clause and saying that gender discrimination, gender classifications ought to be subject to strict scrutiny. 1973, not intermediate, but strict scrutiny. But Brennan, who used to tell his law clerks that his greatest skill was counting to 5, only managed to get 4 votes for that opinion. The 5th vote to invalidate this military-dependent law in Frontiero was provided by Justice Lewis Powell. And it's his concurring opinion that I find so fascinating in the present context. Listen to what Powell had to say in 1973 about why he was not ready to apply strict scrutiny to gender classifications. He says, quote, "There is another, and I find compelling, reason for deferring a general categorizing," I'm sorry, this sentence is so bad. Please don't use this many gerunds in a sentence. Part of my job is that I edit briefs, and so I'm sorry to the ghost of Lewis Powell on Halloween, but let me start. "There is another, and I find compelling, reason for deferring a general categorizing of sex classifications as invoking the strictest test of judicial scrutiny. The Equal Rights Amendment, which, if adopted, will resolve the substance of this precise question, has been approved by the Congress and submitted for ratification by the states. If this amendment is duly adopted, it will represent the will of the people, accomplished in the manner prescribed by the Constitution. By acting prematurely and not unnecessarily, as I view it, the court has assumed a decisional responsibility at the very time when state legislatures functioning within the traditional democratic process are debating the proposed amendment. It seems to me that this reaching out to preempt by judicial action a major political decision which is currently in process of resolution does not reflect appropriate respect for duly prescribed legislative processes," end quote. So, and by the way, if you read The Brethren by Bob Woodward and Scott Armstrong, which is still the best and by far the dishiest book ever written about the Supreme Court, you'll discover that at the time of Frontiero, all the justices assumed that ERA was speeding to passage. Everybody assumed that in early 1973. So you get this strange and arguably vicious feedback loop, right, where the seeming inevitability of ERA stops a majority of justices from adopting strict scrutiny under the Equal Protection Clause, while at the same time the court's foray into safeguarding gender equality under equal protection arguably inhibits the passage of ERA. All right, so for some unknown combination of reasons, the momentum for ERA starts to stall around 1973. And now's a good moment for me to come to what Larry was mentioning, and that's the fact that when Congress sent ERA to the states in March of 1972, it attached a time limit. Now, the time limit was not part of the text of the actual ERA. If you go and you look at the 18th Amendment prohibition or the repeal of prohibition or the 20th Amendment, they do have time limits in their text, but ERA doesn't. Still, according to the congressional resolution that accompanied the passage of ERA and sending it to the states were given 7 years to ratify it. And as the deadline of March 1979 approached, ERA was still 3 states short. So Congress went back and adopted a new resolution extending the deadline to 1982, June of 1982. But in those 3 extra years between 79 and 82, no new states signed on, and indeed 5 states took action purporting to rescind the approval that they had already given to ERA. Now, some people think that those rescissions were legally ineffectual, but no matter how you slice it, ERA, as we sit here today, where I stand and you sit here today, is still short of the magic number of 38 ratifying states by 3. And seemingly, the clock ran out in 1982. Speaking of the states that rescinded their ratifications, one of them, Idaho, went to a federal court and got a declaration in 1981 that its rescission was valid. That case was then appealed to the U.S. Supreme Court by the National Organization of Women. And in 1982, now got a rather awkward decision from the Supreme Court, a one-line per curiam order saying that the case had become moot because the 1982 deadline had come and gone. In other words, the court seemed to be saying any judicial declaration with respect to Idaho's rescission was irrelevant because ERA was dead in the water. Now, of course, per curiam decisions without full briefing and argument are not entitled to full precedential effect, but that's an awkward decision for ERA supporters. On the brighter side, for ERA advocates are 2 other precedents that I want to mention before I close. One judicial and one non-judicial. The judicial precedent is a case from 1939 called Coleman versus Miller. And Coleman dealt with an earlier progressive era amendment, the Child Labor Amendment, which would have given Congress the power to regulate child labor. And what the court held in that case was that the question of whether a particular amendment has A, been validly ratified in a particular state, and B, whether the amendment has sort of been on the table nationally for so long that it's now untimely. Both of those questions are political questions that are up to the U.S. Congress to decide. So that was an important decision. An earlier case had suggested that when it comes to constitutional amendments, if they're sort of pending for too long, like milk that's left out of an icebox, they sort of eventually go sour, and that the court can decide when that moment arrives. But Coleman said, no, it's up for Congress to decide when that moment arrives. So that's one judicial precedent. The non-judicial precedent is the wonderful story of the 27th Amendment, also known as the Madison Amendment, although the nickname kind of confuses me because Madison wrote the whole Bill of Rights, so why does he get his name attached to this one particular amendment? Not clear. But let's pick up that story in 1982. In that year, a University of Texas undergraduate sophomore named Gregory Watson was casting about for a term paper topic in a government course, and he discovered that back in 1789, James Madison had gotten Congress to send to the states, along with the Bill of Rights, a forgotten amendment that said Congress can't vote itself a pay raise without an intervening election. Watson did some research and learned that 6 states had ratified that amendment back in the 18th century, that Ohio, weirdly, had ratified it about a century later, and then Wyoming, even more weirdly, another century after that, but that was all. Okay, so 8 states. And Watson thought this amendment's a great idea. It doesn't contain a time limit, he noticed, so he urged states to ratify it, and amazingly, in the pre-internet 1980s, Watson's idea went viral. And by 1992, the requisite number of states had ratified this 203-year-old amendment, and it's now the 27th Amendment to our Constitution. Meanwhile, back in Texas, Watson's term paper got a C. So, when you put Coleman and the Madison Amendment story together, the theory would be, and I take no position on this theory, but the theory would be that if an 18th century constitutional amendment, forgotten for 2 centuries, can be revived, unfrozen caveman lawyer style, and slotted into the Constitution, right, then ERA, which admittedly did have a time limit, but the time limit was only in the accompanying resolution, right, can also be revived. And then, assuming that those 5 state rescissions are invalid, which is a big if, ERA proponents can pursue their 3-state strategy. There are only 3 more states needed, and as long as they can get Congress to pass a new resolution extending the time limit, or simply getting rid of the time limit altogether, which Coleman versus Miller suggests Congress has the constitutional unreviewable power to do, then at least in theory, ERA could be revived after all. And with that, I'll leave it to the rest of the panel. Thank you.
We're in a political process right now to elect the President of the United States. We have the first woman candidate who looks like she has a very good chance of becoming the next president. And we realize that the most important demographic that politicians are worrying about are women voters. Some of those Trump voters are male, but I'm not sure we're worried about them. We know what they're going to do. But it's the women who will decide this election. I look out in this audience and I see I can count the men who are here on one hand. That shows the importance of this amendment to the women who are professionals, non-professionals, in every aspect of life, including my daughter, my granddaughter, as they're going to go through life. That's why this has been an issue taken up by our next 2 speakers. First, Senator Steans will talk about the politics of what it's like to try to revive something that people, for the most part, think died in 1982. Senator Steans.
Yeah, I did get a lot of sort of chortling responses, from folks when I would start going around talking to my colleagues that we were going to put forth the IRA again. Like, didn't we do that? A lot of people actually think we've done it, I'll start with that. When you look at sort of the polling results, it's hugely supported by, in any national poll I've seen, always in the 90% that folks support equality between genders. But 88% think it's already in the Constitution, that it is already done. So I think people just sort of have that in their heads that this is not something that's even an issue any longer. I think that's the biggest barrier, quite frankly, to overcome. And again, I'm going to go back to, I know Larry said it, the constitutional amendment that we put forward, the actual language of it is equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. I would go around and actually talk to my male colleagues who, particularly some downstate who might have concerns, when they read the language, they say, and there's a debate? When you actually look at what it says and suggests, I don't, it's hard to believe that there is even a question about it. But there is for a bunch of reasons. And I want to talk a little bit about why I think it is still relevant today in our political situation that we're in, why it matters. I'm not an attorney here. I really found illuminating the case that David was making on this. And Colleen Connell had come down from the ACLU and testified for me, making and really demonstrating why having an equal protection clause in the amendment, the Constitution for Illinois, is just not the same protection that you get if you do it at the U.S. level. It's clearly not the same standing. One of the concerns we have is that there have been a lot of work at various state levels, many states across the country, to really roll back some of the hard-fought gains women have had. Certainly we've been seeing it on a daily basis practically on what's happening on abortion rights, for example, and how many laws have been changing that. When you don't have that constitutional basis, states can then make their own determinations on what constitutes equal protection. And very, very much are interpreting it in very different ways, and we see that constantly. So having a frame around the entire country that provides that, I think, is incredibly important still, and still rings relevant, I think, to women today by seeing the kind of support that we've been getting and the young folks that have been starting to get involved on this issue here in Illinois. We also have found that the kind of differentiations we see for women have not gone away in a number of different ways. Certainly it's indisputable that women still don't get paid on an equal basis as men. The data that shows you that women make 77 cents on the dollar of men. African American women are 65 cents, and Latinas at 55 cents compared to men. That's really been incrementally changing. I think it may have inched up to 79 cents, but it's not been changing very significantly over time. We've sort of been stuck on that. Ruth Bader Ginsburg also noted that every constitution written since World War II includes provision that men and women are citizens of equal stature. Ours does not. So, when we as a country try to go out and argue and try to state when other countries have real issues of inequality and how women are getting treated, we don't really have the stature in lots of ways to be making that compelling case around the world globally when we're one of the few constitutions, certainly in recently done constitutions, that don't even have that ourselves. I don't think it puts us on the same stature morally to be able to make that compelling case internationally when we operate. And then finally, Illinois is really where the Equal Rights Amendment died. I think it's a huge blemish on the state. I was reminding my dad recently, back when it was getting debated, I was maybe 12 or 13 here in Illinois, and he and my mom were against it. I remember this strongly. He, when I was reminding him this recently, couldn't even believe that he was against it. It's like, oh no, made a big imprint on this daughter of his. Dad, he only has 3 daughters too, by the way. But the Phyllis Schlafly's had really were their stand here. They're standing their ground here. They did things here in Illinois. They were making homemade bread, jams, and apple pies and bringing them around to Illinois state legislators. They had the slogans that were preserve us from a congressional jam, vote against the ERA sham. That was one of their big ones that went along with their homemade jam and bread. I am a mom for apple pie. I am for mom and apple pie. was the one that they were delivering with their apple pies that they were making. They had little girls wearing signs saying, "Don't draft me," that they were carrying around. And then it got so ugly that the proponents for the ERA actually ended up, I don't know if any of you remember this, writing the names of their opponents in pig blood on the floor of the Capitol in Springfield. It was very heated, very contentious. And I feel strongly that this is a blemish on Illinois' record that we should really be rectifying and putting straight. I think that is a strong statement on who we are as a state. I think it surprises people when they learn that this really is the place that it was killed. I think this was sort of ground zero for that. We did take it up in the Illinois Senate. We've actually had a vote on it now on May 22nd in 2014. To pass it, you need 3/5 vote. We have 59 state senators. We needed 36 votes. We got 39 votes, yes, 11 no, 6 present. And of the 39, we had 2 Republicans, Kirk Dillard and Christine Radonio, were the 2 at the time who voted yes. The other women legislators on the Republican side voted present, which I think they were sort of heartbroken to be taking that position, but felt like it was a political statement that they were making, that they didn't want to try to encourage or give a win to what was perceived as in the Democratic versus Republican gubernatorial race. Is why I think they ended up doing that. It was not hard to get folks signing on, truly. I mean, it just became that political debate. I think one of the compelling reasons is there's this new 3-state strategy. Florida and Virginia, as well as Illinois, are the 2 other states where there's been a really concerted effort to try to do this. I think people think that those are the places where they have the best chance of advancing it. We did get it done in the Senate. Now I'm hoping under the astute leadership of Lou Lang, who's really gotten incredibly tough legislation done, that we'll be able to get it in the House. I think, obviously at this point we'd have to have it come back to the Senate because you have to pass something in the same chamber, in the same General Assembly, which lasts a 2-year period. So we would now, and our strategy now is to have him get it done in the House first. I think the Senate can continue to pass it. So once we have a vote, if we can get it done in the House, I think we can get it done in the Senate. There was not resistance from our leadership on getting it to the board on the floor for a vote. I think it would only get more votes, quite frankly. I think 39 is probably the floor at this point if it gets through the House. So with that, I will end and turn it over to Lou Lang. And I just say that the fact that you guys are having this kind of a conference on this topic, I think helps lend real credence to us taking this up and getting it passed. So I appreciate the attention to it, because the biggest thing really is, truly the biggest hurdle we had to overcome was just a sense of it's just not needed any longer. And I think understanding and developing that sense that we truly don't, because people just think we have the same protections, that we really truly don't. You've seen Antonin Scalia, I know that doctrine you talked about, he was actually quoted in 2010 as well, saying himself that, he does not believe that certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't. That's a direct quote from him in 2012. I hope we don't go back. I don't think we'll have the entire Supreme Court going that direction, and certainly Dave would have a lot better handle on that than I do. But I think the possibility is there, and why in the world we don't ensure that can never happen, particularly when we see what's going on in each state, I think really is important. So thank you very much for your attention on this and your help. Appreciate it.
One of the things that Senator Steans talked about is that each General Assembly is its own world, and the current one expires on January 12th, 2017, and we start a new one January 13th with the swearing in of those who will be elected in 10 days. When I started to go to Springfield for the CBA, it was 1980, and so the ERA was still alive, and I got to meet Phyllis Schlafly and her Eagle Forum people because the Bar Association was one of her targets trying to figure out why we weren't on her side, because she was, after all, an Illinois lawyer, let's remember. But as Sharon reminded me in our preparation for this, she started most of her speeches by thanking her husband for giving her permission to be at this public forum. So she had a very different approach. And I told the group here, I got to know Mrs. Schlafly because she'd be in the Capitol, and you're around the Capitol. And in 1988, she was in Rome opposing a synod of bishops that the Pope had called, and I was in Rome with Cardinal Bernardin as a support group for him, and she opposed everything he said. And I once debated her in St. Peter's Square on German television over what was going on in the Catholic Church, and her beliefs on the Catholic Church were identical to her beliefs on the ERA. So it was amazing that she couldn't separate church and state. But one thing I remember most dramatically, besides the blood, which was the pig's blood that was used often, was that a group of women who were in favor of the ERA chained themselves to the podium within the House chamber. And they were trying to get then Speaker George Ryan to call the bill for a vote, and he refused. And there was a fella named Kelly, who was a state representative from Rockford, who was probably twice as big as I am. And I watched him walk into the chamber and walk up to these women who were chained to the podium. And there was a passive, other than the chains, it was a passive demonstration. And he went over and he started stepping on their feet. I mean, it was just, it was outrageous. But even having that kind of activity didn't cause the passage of this. Lou Lang came to the General Assembly in 1987. Heather came in 2008, so she's a baby of this generation. Lou's a baby of the last generation. But the ERA is in the DNA of the district that Lou represents. His predecessor in the General Assembly was Alan Greiman, who was the sponsor of the ERA from 1976 through 1982. Lou took up the cause when he became the representative from this district, and he has been a proponent of equal rights, women's rights, since then. So I'd like you to now have Lou give you a little longer version, because it's the House, unfortunately, where we continued to have the problem that we had in the 70s. The Senate had twice, I think, passed in the 70s the ERA, but the House never quite got there. Lou?
Good morning, afternoon. I want to get a tape of your debate with Phyllis Schlafly. I hope it's not in German. Good afternoon. It's a great pleasure to be here to talk about an issue that's been important to me for a long time.
I'm not sure what you said.
Quite sure important.
Thank you, Sheila.
Is that Siri?
No, that's Sheila Murphy behind you.
Oh.
She is dealing with her...
She's our Siri.
Sorry.
I became interested in this shortly after I became a legislator in 1987. And I, almost every 2 years since then, introduced an ERA resolution for ratification in the House. As Larry said, each legislature is different. You have a different combination of people. And you know, when you first read the language in the ERA resolution or in the what was passed by Congress so many years ago, you say, well, this is a no-brainer. Why wouldn't somebody be for equal rights for women? And I think the answer lies in politics. For some people, their politics, because of the communities in which they think they live, are, for whatever reason, reticent to support this. And it's because of people like Phyllis Schlafly and others over the years who have fed political misstatements to folks who have gotten them nervous about their re-election. It's unfortunate, of course, when politics gets in the way of good public policy, but Illinois being what it is, and it's been this way a long time, oftentimes politics gets in the way of public policy. And so you've heard some of the arguments people made. They said it'll mean abortion on demand. Nonsense. There's nothing in the ERA resolution about that. It'll mean gay marriage. Well, guess what? I don't think we have to worry about that anymore. It'll mean women will have to be drafted, and it's just silliness, because there's nothing in the ERA that confers extra powers upon government to force women or men to do anything. The ERA is simply a document and a statement of the regular rights of ordinary people in our state and in our country to live their lives as equal citizens in the United States of America. It's interesting to note that Illinois, as do many of the states that have yet to ratify the Equal Rights Amendment, has an equal rights clause right in our own Constitution. So the Constitution of the state of Illinois basically has an equal rights amendment in it. And so when you approach certain legislators with that, you would think they would say, well, you're right, if it's good enough for Illinois, it's good enough for America. But instead, those that are predisposed to be against this resolution actually go the other way. They say, then what do we need the federal Constitution for? Women have all the rights they need right here in the state of Illinois. And of course they don't. Whether it comes to equal pay or an ability to borrow money or to lease an apartment or other property or any other type of financial transaction, women are still behind the eight ball. There are still bankers that ask women for co-signers. There are still landlords that ask women for co-signers on leases. And so in a day and age where you'd think the population was enlightened and the legislature was enlightened, there are so many reasons that many of our colleagues have been slow to get on board. In fact, in the 90s, we did pass in the Illinois House an equal rights resolution. We passed it first there, and we sent it over to the Senate, and it never got called for a vote. And I could get into that, but I won't. So it has passed both chambers, but not at the same time and not together. And then, of course, there are those that have buried their head in the sand, and they look at the Equal Rights Amendment language, and they say, well, it's not strong enough, so I can't be for it. But we don't have an option of making it stronger. The states cannot amend what came out of that congressional passage so many years ago. This is the language. The language has been read to you a couple of times, and we either have to ratify it or not. Now, I have traveled to Florida 3 times to try to help the Florida legislature move this process along, but unfortunately what they say to me is, Representative, we'll never get it passed in Florida until you do in Illinois. And I think they're probably right. Both Florida and Virginia are waiting desperately to see however many more years it takes for the state of Illinois to do the right thing. You can be helpful in this process. Each of you has a state representative and each of you has a state senator. I'm going to guess many of you don't even know how your state representative or state senator voted the last time these were up in the House and Senate. We did not take the resolution up in the House this year. Many said, well, why don't you take a vote on it? It passed the Senate. It's going to pass the House. Go for it. But I chose not to do that because I can count. And as I went around and talked to the members of the House, I just simply didn't have enough votes. Had almost enough votes. You need a 3/5 majority in each chamber. You need 71 votes in the House. And I had something like 66 or 67, which is a majority, but not enough, members of the House prepared to vote for this resolution. I spent a good deal of time with women on the other side of the aisle who are bright and caring, for the most part. And these were folks who, for some reason, were opposed to ERA, and I could not move them off the dime. So the way to move them is to have citizens of Illinois, their own constituents, contact them, urge them, talk to them, and tell them, what are you afraid of? You serve in a body where you have pledged to provide equal rights to people. Maybe you didn't vote for gay rights. Maybe you didn't vote for equal rights. And there's a lot of people in the political world, it will not surprise you at all, that talk a great game about equal opportunity and fairness and all of these rights that are up in the clouds someplace for them. But when you bring them a specific piece of legislation to vote on, they aren't really paying attention, or they're hiding, or they're afraid of some kind of backlash, which is the silliest thing I've ever heard of, really. Our prospects to pass this anytime soon frankly, depend on the November election. Not who's elected in Washington, but who's elected in Springfield. Every member of the Illinois House is up for re-election. I think 2/3 of the Illinois Senate is up for re-election. And it's important that those of you who are here because you're concerned about this topic, not just because you're here to get the CLE credit, pick up the phone and make some calls and find out over the next several days, because you only have a few days left, find out where your elected official or the candidate running against your elected official stands on these issues. We can be helpful in that process if you call us, I think. But it's in an important way, people of Illinois can affect this. If we elect a few, frankly, and I don't want to make this political, but we're here to tell the truth, if we elect a few more Democrats to the Illinois House, we may actually get to the goal line. If we don't, we probably won't anytime soon. And I don't want you to think every Democrat's in favor of this, because if they were, we'd have passed it already. We've got a lot of downstate Democrats, more conservative Democrats, and central and deep southern Illinois that have fallen prey to the narrative that's out there that somehow this is dangerous to our state and dangerous to our country, and it's going to cause all kinds of havoc in government. It's certainly not true, but I haven't been able to convince some of them either. So I'll make you a deal. Help us elect more people to the Illinois House that care about this, and I'll continue to work on all of those folks. Thanks for having us here today.
One of the things that happened in Illinois in the first go-around between 72 and 82 is we had a different composition of the Illinois House. We had 177 members instead of 118. It was in 1982 that the reduction amendment passed that reduced the size of the House by 1/3. So we were in a better fighting position, because now we have much smaller margins for people like Lou to work with in the House. I'm glad Lou mentioned the other two states in the three-state strategy. But in fact, the leadership to get the three-state strategies will have to come from Illinois. Florida, even though it's a larger state, clearly is waiting for Illinois to operate, as Lou said. And Virginia is just Virginia. It's waiting for somebody to tell it what to do. So hopefully we will be the ones that will do it. David Franklin gave you the outline of kind of the history and the legal issues that brings us up to this point in time. What we'd like to do now is have Deanna Brown talk about the practical implications as a lawyer practicing with an employment discrimination practice today, and what effect the Illinois Constitution, the many state and federal statutes have on the issue, and why, in her practice, passing a federal constitutional amendment would mean something. Deanna.
Thanks. Good afternoon, everybody. So as Larry said, I focus my practice on representing executives in employment disputes, including sexual harassment, gender discrimination in violation of Title VII, and in violation of the Pregnancy Discrimination Act. So I wanted to talk a little bit about what I see, have seen, cases I actually have in my practice, without identifying any names, and the legal tools that I currently use when bringing lawsuits on behalf of those clients, and what might happen if the ERA is passed. First of all, let's talk about just typical gender discrimination cases. So it's very rare for an employer to come out and say he doesn't like an employee because she's female. They're not usually that silly. But what they do instead is there are more subtle forms of gender discrimination. For example, in a sales job where a woman or a man is heavily dependent on their commissions, I've seen employers purposefully assign men to better clients or more lucrative territories than women. I see men who are getting ready to retire and they want to transition their client relationships to younger men, and not necessarily women. So they do that by bringing these younger men out with them to play golf and to quote-unquote gentlemen's clubs, so they can better get to know the clients, and that's business that will inure to that man. Men will help other men help bring in business, give sales credit to other men so that those men look good, just help out one of the guys. That's the kind of subtle gender discrimination I've seen. So I currently have a case right now where my client was one of the only women in the high-level IT sales positions, where she developed the client relationships She'd been doing this for years, and she should have received the commissions from all of those sales. Her boss, however, didn't really want to work with a woman, so he basically took her off the accounts that she had personally developed and reassigned them to men. So not only did that have the effect of depriving her of commissions, to which she was entitled, but also stopping her from reaching her sales goals, so suddenly she became a quote-unquote poor performer, and she was terminated. So I'm arguing that the employer's actions in that case violate Title VII of the Civil Rights Act of 1964, because that forbids a covered employer to discriminate against any individual with respect to terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, and national origin. And that was a quote of Title VII. It doesn't apply to everybody, though. There's some gaps in that. For example, a covered employer under Title VII has to have at least 15 or more employees for each working day in each of the 20 or more calendar weeks in the current or preceding calendar year. The Illinois Human Rights Act, however, when we're dealing with sexual harassment, only requires that that the employer have one employee to be covered. However, it's important to note in today's world, especially, that the definition of employee under Title VII does not include independent contractors. It also doesn't include any person elected to public office of any state, including judges in Illinois. In another case I have a female financial advisor who was in charge of recruiting new advisors to this investment company. And somehow the employer always found reasons to reject the advisors that my client would recruit by applying higher standards to those potential recruits than the ones that the men tried to recruit. And on top of that, there was no women in management at that particular company. And I ended up filing a gender discrimination suit, again under Title VII, and that matter settled. In a different case, I represented one of only a few high-level women in a very large company who couldn't advance because of what we all know as what's called the glass ceiling. She was a woman. There were 0 women in management at this company. And this is a true story. At a national meeting with thousands of men and women, the company actually showed a video of 3 men in a urinal, only from the top up, where one man helped another man light up a cigarette by appearing to hold his genitals towards the urinal, while another man helped another man pour himself a drink by holding that man's genitals towards the urinal. The message of the video was teamwork. Oh, yeah. So, true story. So when my client complained that the video was offensive to women, as was the message that teamwork could only be accomplished in a men's bathroom, thereby she was engaging in protected activity by complaining, she found herself retaliated against. There were very few women in upper management. I filed a lawsuit for gender discrimination. After several very interesting depositions where we showed the urinal video repeatedly, that case also settled. Now, so the gender discrimination cases are one category. Sexual harassment is another category. I had an amazing case where a female HR director was actually harassed by her boss, a senior HR director, in a Fortune 100 company. As unbelievable as that sounds, she was actually subjected to unwanted touching, offensive remarks, lewd gestures repeatedly, again, from an HR director. But luckily for her, because she is in HR, she knew to document everything very well. Times, dates, offensive activities, witnesses. She complained, so again, engaging in protected activity. Soon after, she found herself out of a job because her position was purportedly eliminated. Again, I filed a Title VII federal lawsuit alleging both sexual harassment and retaliation. The case landed before a female federal judge. We were immediately sent to a federal magistrate to settle the case before I even took a stitch of discovery, and that case settled. But my client was unusual in that regard because she actually knew what her rights were. She knew the importance of documenting everything, and most women in the workplace don't necessarily know these things, and worse, women fear retaliation if they complain about being sexually harassed. Even though there's rules and laws to protect against that, the reality is a lot of women need these jobs. They need their jobs, and they're very afraid to speak up. And then the last thing I want to talk about before we get into the legal tools is Pregnancy Discrimination Act. As many of you know, the Pregnancy Discrimination Act amended Title VII. It amended it in a couple ways. It amended the definition of sex to include, quote, on the basis of pregnancy, childbirth, or related medical conditions. And then it added a second clause that states, quote, women affected by pregnancy, childbirth, or related medical conditions shall be treated the same for all employment-related purposes as other persons not so affected but similar in their ability or inability to work. So believe it or not, once that became the law, it didn't dissuade a number of employers. I've represented 3 women who were actually fired on maternity leave, and another one who was terminated shortly after telling her direct supervisor that she was pregnant and that she intended to take a maternity leave. Suddenly, amazingly, all these women became quote-unquote poor performers, and in an attempt to justify their terminations, or their jobs were somehow eliminated. But one of the main things I like to do is go right to their personnel files and look at all their raving, wonderful reviews and sort of put the kibosh on that. And generally, those cases also tend to settle. But the legal clients, what do I do? How do I help my clients? What are the tools that I have right now to use? So again, I generally try to resolve things amicably because lawsuits, as we know, are very time-consuming. They're very expensive. I will write demand letters to employers, advising them that they're in violation of Title VII, or the Pregnancy Discrimination Act, the Illinois Human Rights Act. Sometimes, when those demand letters don't work, I go to the Equal Employment Opportunity Commission, the EEOC, the federal body, and then the Illinois Human Rights Commission. They'll investigate those claims, they'll mediate those claims. Unfortunately, and it's rare that they'll actually bring a single plaintiff claim to prosecute the claims. So generally they'll issue a right to sue letter. That's the letter that we need to attach to file in federal court or state court. And then the good news for a lot of plaintiffs in the federal district is the judges' dockets are clogged with these federal claims because there's all these federal statutes that protect employment rights, and they tend to push settlement, which is often good for a plaintiff's lawyer, and that the cases usually do resolve themselves. Now, this is a recent shift, actually, that occurred very recently, August 19, 2016, in the 7th Circuit on proving discrimination. The 7th Circuit recently held that the applicable legal standard of proof in an employment discrimination case is, quote, whether the evidence would permit a reasonable fact finder to conclude that the plaintiff's protected status caused a discharge or other adverse employment action. In that case is Ortiz versus Werner Enterprises, Inc. Again, that came out August 19, 2016, which is, I think, a little bit better standard for plaintiffs than the typical direct or indirect evidence methodology under McDonnell Douglas. Again, lawsuits are time-consuming and expensive, better to avoid them, but those are the tools we currently have. So how can the ERA help? Well, right now there are definitely gaps in the current gender discrimination laws that the ERA could help to fill. For example, like I mentioned before, independent contractors aren't protected under Title VII, but I believe would get some protection from the ERA. And right now, the Pregnancy Discrimination Act, which we discussed, that amended Title VII, does not require any employers to provide minor workplace accommodations that are needed by pregnant employees, such as being allowed to take more frequent restroom breaks. Again, that's only women, as far as I know, who can become pregnant. So when it is only women who are harmed by a policy, the fundamental principle of equal rights on the basis of sex is violated. There's a couple cases, they may even be in the materials that you picked up when you came in. Weissman versus Walmart is a 2009 Kansas case, District of Kansas case, where a pregnant employee began suffering from intermittent urinary and bladder infections because of her pregnancy. So her doctor said drink a lot of water, remain hydrated. She was working at Walmart, she was carrying a water bottle around, and Walmart said, no, you can't do that because we have a policy that says you can't carry water bottles. So she did it anyway because she was concerned about her health and the health of her pregnancy, and she was terminated for insubordination. She filed a lawsuit under Title VII, and she lost her case. There's another case that made it to the Supreme Court. You probably heard about this, Young versus UPS. In that case, that was a delivery driver who was pregnant, Peggy Young. While she was pregnant, she wasn't supposed to lift more than 20 pounds, but UPS required its delivery drivers to lift 70 pounds. So even though, by the way, UPS had a light-duty policy that it would give to employees who suffered from disabilities that were not temporarily able to fill their job's physical requirements. But they wouldn't do that for pregnancy because that didn't qualify for light-duty assignments. She was dismissed without pay and benefits on the basis that she couldn't do her job. The lower courts ruled in favor of UPS, but the U.S. Supreme Court, it was a 2015 opinion issued by Justice Breyer, held that there was actually a genuine issue of material fact which precluded summary judgment in that case. The Supreme Court held that an employee in a Pregnancy Discrimination Act case can create a genuine issue of material fact as to whether an employee's policies impose a significant burden on a pregnant employee by providing evidence that the employer accommodates a larger percentage of non-pregnant workers while failing to accommodate a large percentage of pregnant workers. So, so there's a lot to be said for how the ERA could play out in those kind of cases. The other thing that may or may not be in your materials is systemic bias. So I believe that the ERA could provide the possibility of recourse when women are clearly disadvantaged by unequal treatment without having to prove intent to discriminate. David talked about the Equal Protection Clause of the 14th Amendment, but right now it prohibits states from denying any person within its territory the equal protection of the laws and requires that unequal treatment be intentional to be illegal. So a lot of sex discrimination on the systemic basis isn't necessarily intentional, but so the ERA could help in those kind of cases where there's a clear pattern of disadvantage to their sex, to women's sex, without having to demonstrate intent. A couple cases, Bray versus Alexandria Women's Health Clinic, a Supreme Court case from 1993, and that was a case where an abortion clinic and abortion rights organizations tried to enjoin an anti-abortion organization and its members from trespassing into an abortion clinic and blocking access. The clinic tried to argue that since voluntary abortion is an activity engaged in only by women, to disfavor its ipso facto discrimination invidiously applied to women as a class in violation of the 14th Amendment. Equal Protection Clause, the Supreme Court said no. You have to have invidious discrimination. There has to be a discriminatory intent such that a decision maker selected a particular course of action, at least in part because of its adverse effects on an identifiable group, and they said that wasn't the case with abortion. There's another case, Goldudik versus Aiello, another Supreme Court case that was from 2004. Supreme Court said a state disability insurance system that denied coverage to certain disabilities related to pregnancy did not violate the Equal Protection Clause. The court stated, while it's true that only women can become pregnant, it does not follow that every legislative classification concerning pregnancy is a sex-based classification. And then one more case, Personnel Administrator of Massachusetts versus Feeney, another Supreme Court case, 1979 case. The Supreme Court denied an Equal Protection Clause challenge to a Massachusetts law giving employment preference to military veterans, a class in Massachusetts which was over 98% male. So again, there was no invidious intent to discriminate, but if the ERA can take away that element of intent to prove systemic bias against women, I think that would be extremely beneficial to women. And my time's up, but I'm sure we'll talk more.
Keep going.
I have one more section I just want to talk about, and this might be part of our questioning later, about transgender and LGBT communities. So right now, those are two, if you're transgender or a member of the LGBT community, you're not protected under Title VII. Its sexual orientation is not protected. It is protected under the Illinois Human Rights Act. The ERA, as we've read it today, generally refers to sex, right, as that term is used. I believe that the passage of the ERA would cover transgender individuals and members of the LGBT community because, and one of the reasons I think that is because in March of this past year, for the first time, the EEOC began prosecuting sexual orientation cases in sex discrimination, as sex discrimination in the private sector under Title VII. They had not previously done that. There's a case going in the Western District of Pennsylvania, EEOC versus Scott Medical Health Center, and in the District of Maryland, EEOC versus Pallet Companies. The EEOC stated in those cases that sexual orientation discrimination necessarily involves treating workers less favorably because of their sex, because sexual orientation as a concept cannot be understood without a reference to sex. Sexual orientation discrimination is rooted in noncompliance with sex stereotypes and gender norms, and employment decisions based in such stereotypes and norms have long been found to be prohibited sex discrimination under Title VII. So sexual orientation discrimination punishes workers because of their close personal association with members of a particular sex. So if you look at the ERA and the use of that word sex, I do believe that would be a benefit to members of the LGBT community. I did want to conclude with one very, very recent case that was surprising. It came out of the Seventh Circuit in 2016, Hively, H-I-V-E-L-Y, versus Ivy Tech Community College, 830 F3rd 698. In that case, a part-time adjunct professor argued she was denied full-time employment and subsequent promotions due to her sexual orientation. She filed the case under Title VII. The claim was unsuccessful because, as we've discussed, sexual orientation is not currently a protected class. But the court stated as follows, quote, "Perhaps the writing is on the wall. It seems unlikely that our society can continue to condone a legal structure in which employees can be fired, harassed, demeaned, singled out for undesirable tasks, paid lower wages, demoted, passed over for promotions, and otherwise discriminated against solely based on who they date, love, or marry. The agency tasked with enforcing Title VII does not condone it. Many of the federal courts to consider the matter have stated they do not condone it, and this court undoubtedly does not condone it. But the writing on the wall is not enough. Until the writing comes in from the form of a Supreme Court opinion or new legislation, we must adhere to the writing of our prior precedent, and therefore the decision is affirmed. However, the good news, oral argument is now set for November 30th, 2016. The Seventh Circuit recently granted a petition for an en banc hearing in order to review that case, which they're very rare, and it'll be really interesting to see what comes out of that. So thank you for your time, and hopefully we'll have a further discussion in front of the panel.
Do we have some questions that have been submitted?
I'll check, but no, I'll check.
Oh, okay. The people who put the program together gave me some questions that I'd like to just start off with just to the panel, and then we'll get the questions from those of you that are here. I think that Deanna just went through some of this, but the question I've been given is, what are some of the specific benefits that women, and even men and women equally, including transgender individuals, will realize if the ERA is passed? Is it enough to have local and state laws that mandate gender equality? And I'd ask the legislators this because they're dealing with other people who are voting on legislation. And as we saw from Deanna, the courts, feel like in many ways they're stuck at certain points in this, and they're looking for new legislation. So either Heather or Lou.
The problem we face as we try to pass this resolution has little to do with the state of the Supreme Court or the state of the law. This is purely a political problem. We talk till we're blue in the face to recalcitrant members in the House and in the Senate, more in the House, regarding the facts that women aren't paid equally, that they aren't treated well in the workplace, that they can't rent apartments without a cosigner or buy a car without a cosigner, or all of this. And then we talk about just simple dignity, providing more than half of the population the rights they should be entitled to under our Constitution, the same rights that they have under the state Constitution. And the answers we get back are never about the Supreme Court, and they're never about the state of the law, and they're never about anything other than politics. In fact, many of my colleagues in the House who won't vote for this don't even give me an answer because they don't want to. Because it's easier to vote no if you just walk away from the conversation. And so for us to move this forward, we can continue to educate. But they need more of a political education than they need a substantive education on the state of the law or about the impact in housing for women or financial transactions for women. They need a good talking to in terms of politics. I have to add, though, that if some of these, Heather and I will both have a list of people we think ought to be voting for this who have refused to, because we are at a distance from their district, perhaps, and we think their district is one way and they think it's another, but it's mostly about fear. And those legislators have not had a groundswell of people in their districts, particularly women, go to their offices and say, how the heck can you not vote for this? You should be not only voting for this, you should be sponsoring it. And so there's a whole narrative that goes on district by district by district. It's almost a different war and a different level of war in each district. And so that's why we need to have engaged people on the ground, district by district, all over the state of Illinois, talking to their legislators if this is going to move.
Yeah, just to sort of illuminate that, I did the marriage equality bill in Illinois and ran into a lot of similar kind of issues because we had civil unions already, so we were already providing, those rights. But, clearly there were things that LGBT population could not get from federal benefits, immigration laws, rafts of things when you didn't have it sort of constitutionally done, or done at the federal level. But that's not what was able. I mean, while I would make cases on why we need to go to full marriage equality, there are certain things that you can get from marriage that you couldn't get from a civil union because of these things. What was really able to turn people from no's to yeses was very much that legislative district by legislative district persuasion. And, I mean, we had a whole campaign that really enabled it. One of my concerns is you don't have that same kind of operation in place in Illinois to support trying to do the ERA that we did to get marriage equality passed legislatively. And we literally were, for that marriage equality, person by person, those people that you can point to and say, we believe their districts would support this and they should be there, we would be polling in those districts, and we got that data to them on the marriage equality, and we would go to some people, some legislators that really, they need the sort of leading thinking from their viewpoint, the people that they are going to turn to and understand where they're coming from, needed to go and understand where they were and have them call. I mean, it really is a person-by-person strategy on what it is that it's going to take them to flip to that yes. That would be, I think, the most helpful. Certainly what we saw was able to switch people who had just a few years ago, when we did civil unions in 2011, who said they would never vote for marriage equality, flipped to a yes on marriage equality just a couple years later in 2014. It really was that kind of a engaged legislative campaign.
I have a follow-up question on this. As you talk about the opposition within the General Assembly, is the opposition to the ERA, or is the ERA now the symbol of something they can vote no on to go back home and say that they fought against transgender rights, LGBTQ rights, and this question asked, is the wording of the amendment because of sex, that phrase, is that the one that you run into problems with members? As both of you.
My view is that those are involved, certainly, those assertions that the question assumes, but I think for the most part, the members of the House who are unwilling to vote for this seize upon certain words. These may be people who are opposed to gay rights, and they may be people who are opposed to abortion. And as soon as somebody raises those issues with them, that turns them off to the whole issue. And until we get them back thinking about public policy and thinking about what's right and what's wrong just simply on a moral and ethical basis, it's going to be hard to turn those votes, because those votes are locked in, for the most part, based on politics. Their politics is anti-abortion. Their politics is anti-gay, and therefore they're not listening to reason. They hear those words, and they're immediately off the reservation. And so that's where we have to make our surge in terms of turning those votes around.
And I would add, though, that I think we have an opportunity. In 2014, when I got this done, it was harder to get Republicans because this was being seen as a political wedge tool that then Governor Quinn was going to be able to use if you got this done against candidate Rauner at the time, Republican candidate. Well, now we have a Republican governor in place. If we can get him supporting it, I think that could generate a lot more Republican votes, quite frankly. I think there were a lot of Republican present votes in the Senate who would have flipped to a yes if they didn't feel like it was going to get used as a political tool against them in the election. So I think there is a real opportunity to be able to sort of make this an easier task in the House were that to be the case.
And let me add one more thing. Remarkably enough, I had 4 House members who voted for gay marriage who would not vote for the Equal Rights Amendment, and they said pretty much, I can't vote for both of these. What do you want from me? I'm voting to help gay marriage. That's tough enough in my district. Now you want me to help women too? I heard this from more than one legislator, and it's appalling, but it's factual.
Deanna, did you want to
Well,
comment?
I just had a question for our legislators here. Because the Illinois Bill of Rights actually has, an ERA, how do the people who are opposed to, passing the federal ERA, amending the U.S. Constitution, square that with their position in Illinois?
They don't.
Okay.
Simple enough. David, you have a number of questions that I'll try to put together here. You stated that it's up to Congress and not to courts to determine whether the amendment has been legally ratified. What kind of majority or vote does the Congress have to make that determination?
Right. I believe that that's also up to Congress, and it can establish that by rule. So if I recall correctly, for example, when the ERA deadline was extended to 1982, there was some discussion in Congress about whether that had to be accomplished by some form of supermajority, the way the initial proposal had to be. But it's my understanding, and if others know to the contrary, please feel free to correct me, that Congress has the discretion to determine whether not only whether an amendment has been validly ratified, but what vote it will take to certify that that's happened. So Congress could do it by a simple majority, as far as I'm aware.
I just want to comment on that. I believe I've read cases, and I can't quote what they are, that talk about dates and deadlines in Congress as simply ministerial acts. I think that's the term I saw. And if it's a ministerial act, that would seem to indicate that unless Congress changed their rules, it would require a simple majority, even though the amendment itself required more than a simple majority. A ministerial act like a date or a deadline would simply require a majority, but I can't put my finger on a specific case.
Yeah, I mean, I'll go even further and say that as far as I know, Congress can delegate such ministerial acts to others. So Congress, for example, has delegated, at least in the first instance, the task of certifying the count of states to the archivist of the United States. That's the person who, is the custodian of the original copies of the Constitution that you can go see in Washington, D.C. And the archivist is the one who keeps the official count. Now, Congress has typically gone back and held a vote to certify that count, and it certainly is free to do that. There's the separate question, though, of whether the amendment remains timely, and that's something I don't think the archivist can decide unilaterally.
David, in looking at what we've just talked about what could be a ministerial role of the Congress, and under the congressional rules they can determine what vote it takes. We always warn people that an enactment of one session of a legislative body, be it the Congress, the General Assembly, or even the county board, could be undone by the next grouping of that same body. Could the Congress repeal the resolution that adopted the constitutional amendment in 1972 and start us from scratch?
So I don't know the answer to that question. If the question is, could Congress say, time has run out, and we officially declare that the ARA, as enacted or as sent to the states in 1972, is no longer timely, I think the answer would be yes. By the same power that Congress has to declare that the ERA is still timely, it could declare that it's no longer timely. And that would, I suppose, enable Congress to start over. I'm not sure that there's anything stopping Congress from starting over in any event. This did come up with respect to the Madison Amendment, if I'm recalling correctly. There were some in Congress, although it was not politically advantageous for members of Congress to be seen in public to be supporting the idea of passing pay raises for themselves, right? There were some who nonetheless wanted to be able to do that and who claimed that Congress had the ability to pass a resolution declaring that this 2-century-old amendment was, in effect, stale. And I'm virtually certain that a court would agree that Congress has that power and that it's a political question unreviewable by courts. Congress never got around to so declaring with respect to the Madison Amendment, but I suppose, if I understand your question correctly, it could do that with the ERA.
Was there not a resolution introduced to the Congress with different wording in the amendment by the junior senator from New Jersey, whose name is escaping me, it starts with an M?
Bob Menendez?
Bob Menendez, yes.
I believe that there may have been, but I don't recall what the substantive difference was.
I don't think it went anywhere, but he attempted to change the language to start the process anew. All right, to any of you, does the ERA only prohibit the denial of equal rights by the United States or by any state?
I can speak to that. The text as it was sent to the states in 72 does both. So it says the equality, let's put the language here, we've read it a couple of times already, equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. But it's important to recognize that that text, at least the natural construction of that text, would suggest that the ERA, if it did become part of the Constitution, would contain a so-called state action requirement. So it would not, of its own force, apply to private discrimination, right? So the employer who pays women less than men, or the company that discriminates against female independent contractors, or the insurance company that discriminates in its rates against women as opposed to men, they would not be, as I understand it, directly covered at all by the ERA. Now, it might be. One never knows how a Supreme Court would construe an ERA if it were actually made part of our constitutional fabric. It's possible that the Supreme Court could adopt some more lenient version of the state action doctrine for the ERA than it has done for the 14th Amendment. In the 14th Amendment context, for example, some of you may remember the Violence Against Women Act case from the year 2000, United States versus Morrison, in which the Supreme Court struck down a federal statute that provided a civil remedy for victims of sexually motivated violence against their attackers, saying that Congress's power to enforce the Equal Protection Clause of the 14th Amendment did not extend to the ability to provide for damages against a private defendant, right? So in order for the ERA to even authorize Congress to attack private discrimination, the court would have to adopt as an ERA doctrinal matter a more lenient state action doctrine than the court, in my view, mistakenly adopted in the Morrison case with respect to the 14th Amendment.
Deanne, do you want to comment on that and what you think the passage of the ERA would mean in connection with employment discrimination by private employers?
Right. Well, I think it would have the same, I think it would bolster another tool that we can use to prosecute those cases. Because just like right now, sometimes we try to use the 14th Amendment, the Equal Protection Clause. It's not been that effective, unfortunately. But I think the ERA would certainly be an expansion of that and help us, bring further cases. I think it would close gaps where gaps exist right now. For example, what about employers under 15 people? That right now the Title VII doesn't help us employee lawyers. So I think that would help because that may expand the basis on which you could bring a discrimination claim. I also think that I mentioned before, like independent contractors. Right now, so many employers don't want to pay, benefits and overtime and things like that. They make people independent contractors instead of employees, even though we all know they're really employees. In that sense, they're not covered by Title VII. So I think maybe an ERA would help in that regard as well.
Deanne, where are the majority of lawsuits brought, in the state court system or in the federal?
I would say the federal system. I mean, the states, it's fairly recent in Illinois to allow those lawsuits to be brought. I mean, maybe David could address that, but virtually all of my cases are brought in federal court for a lot of different reasons. But certainly, a lot of the, not just the gender discrimination cases, but the age discrimination, disability discrimination, FMLA retaliation. All of that is all federal.
Well,
I mean, it's state too, but I tend to bring federal.
But they're brought under federal statutory authority.
Correct.
But the constitutional claim is just an add-on to the complaint.
Right.
Okay.
Or you could, but the Illinois Human Rights Act does provide for all those protections, and they can be litigated in state court now.
And since we're into sports this week in Chicago, which court seems to be the better court for the plaintiff?
I'm going to take the fifth.
Okay. Well, yeah, okay. I keep pulling for the Circuit Court of Cook County as a Cook County Commissioner, but you never know. Deanne, I have a question here. It says, if you think the ERA would be good news for the LGBTQ community, is that because the sex as used in the ERA would cover persons who choose a gender different from the gender assigned to them at birth?
Yeah. It's hard to say because that case law right now is evolving. Like I said, the EEOC just picked this up, this idea of prosecuting employers for discrimination against the LGBT community very recently in the private sector, a little less recently in the government sector. So, I think that, but they did it on the same basis, they used the word sex, and they focused on, how can sexual orientation discrimination be anything other than discriminating against people because of their sex? So, I do think that it will be helpful, but again, it's such a new area right now of law that we don't know what the federal courts are going to say about these. Right now, they're rejecting these cases, at least under Title VII. So maybe it would change under the ERA. I just don't know. But I do believe that sort of the wind of change is blowing in that direction, which is a good thing.
David, I'm interested in your view as to whether the rescissions of several states might be deemed either valid or invalid, and by what process and by what body?
I think the by what body is the easiest part of that question, so I'll take it first. That would be Congress, right, under the Coleman principle, right? So Congress has the unreviewable authority to determine whether a constitutional amendment has been validly ratified within the appropriate time frame. In terms of the substantive question of whether those rescissions would be valid or not, it's an open question. There is that Idaho District Court decision which was vacated as moot in 1982. There isn't really any other case law that I'm aware of on this question. I know that some prominent scholars of constitutional law, Professor Van Alsten of Duke, Walter Dellinger, I believe Larry Tribe, have all opined that it would be very problematic to permit a state to rescind an earlier ratification. The notion simply is that there has to be certainty and finality in the process as it goes along, and one has to understand how far along one is at every point in time and so forth. But I don't think there's been anything close to a definitive ruling on whether those rescissions were in fact invalid, and it really matters, right? I mean, if Congress were to determine that the rescissions were valid, then it becomes an 8-state rather than a 3-state strategy, right? So I think the notion, though, is that, look, Congress is already going to have to, as it were, excuse the untimeliness And if Congress has got the political will to do that with respect to ERA, then presumably it would come down on the side of the invalidity of those rescissions. But really, that is all bound up in this political question about what it takes for a ratification process to be completed.
So this next question says, how do you think the Supreme Court would rule on the 5 rescissions? But basically, it sounds like even though the Idaho case got to the U.S. Supreme Court, that's because the Congress wasn't functioning. But if we were at a point where ratification were possible, there would have had to been congressional action, and probably the courts would just find that it is the responsibility of Congress.
I suspect. I mean, the Coleman case is not on all fours, right, with the rescission question. It's certainly possible that the Supreme Court could decide that it was a judicial matter, okay, whether the rescissions had or had not taken place. But I strongly suspect that the court would stay out of it. And additional evidence of this comes from the 14th Amendment itself. So at the time of the 14th Amendment's enactment in 1868, so right after the Civil War, it wasn't yet the Archivist of the United States, but rather the Secretary of State who was tasked by Congress with determining whether an amendment had or had not gone through. And William Seward, our friend from Seward's Folly, the guy who purchased Alaska for us, and ran against Lincoln in 1860, was still the Secretary of State at that time. And he made the determination that some purported rescissions were invalid. This was obviously during Reconstruction, when many of the states of the former Confederacy were under a martial law, in effect. And that other states' enactments were valid, though they were contested at the time. And the courts simply stayed out of that one altogether. And I suspect the same thing would be true in modern times.
The next question relates to the presidential election. What impact can the next president have on, one, the passage of the ERA, or on EEOC enforcement priorities?
On passage of the ERA, as I mentioned earlier, the president has no direct role in the amendment process. But presidents have an enormous role in setting a tone for the country and for the debate. And I will say nothing further about questions of tone setting, but I think we all know what I'm talking
Since
about.
the current president's a former colleague of yours in the Illinois General Assembly, will a former resident of Illinois as president have a difference, or will a New Yorker have a difference?
Well, it's hard to say, but I think it's clear that if this issue were brought to the attention of a president of the United States that was favorable to having ERA be part of our federal Constitution, then a president could go to his or her folks in Congress and say, this is the time to pass a resolution changing the date, ministerial or not. This is the time to say, well, let's pass a resolution saying that ERA is still alive, that 3 more states will do it, or however they want to do it. So a president could definitely have some impact on that process moving forward, even though they have no direct connection to the passage of that resolution.
Absolutely, and again, I saw it in marriage equality when President Obama came out for marriage equality. When he did, I saw it change some of my colleagues' no votes to yes votes. I had some specifically speak to me. I listened very carefully to what President Obama said, and I'm going to support it now. It's just the strong, compelling, power of the pulpit. It's not, there's no legal basis for it, but absolutely would set a tone and be helpful if that were to become a priority.
And as far as the EEOC guidelines, the EEOC is technically an independent agency, so the president doesn't have the power to just fire members of the EEOC at will. But again, presidents have enormous practical authority with respect to all agencies, not just executive ones.
Deanne, have you noticed, since you've practiced with Democratic presidents, Republican presidents, Democratic presidents, any change in direction at the EEOC that was dramatic, or do they maintain the independent role that it was intended to have when created by the Congress?
I mean, I think they do maintain the independent role because they have to, but I will say that at least in 2000, for fiscal year 2013 to 2015, the EEOC published what they called a strategic enforcement plan, and they identified a number of national priorities in that plan. One of those priorities was addressing emerging and developing issues with respect to coverage of lesbian, gay, bisexual, and transgender individuals under Title VII's sex discrimination provisions as they may apply. So by setting national priorities in this plan, I think that, in fact, and then carrying out the plan, like in the cases that I've talked about, I certainly think that they have a role to play since they are the body that's charged with enforcing federal law in terms of discrimination.
There's another federal agency that is an executive agency that's quite important, especially with respect to the rights of young people who are transgender, and that's the Office of Civil Rights at the Department of Education. Of course, they've recently issued the guidelines on transgender locker rooms, changing rooms, bathrooms, and so forth, to put forward the argument that the reference to sex in Title IX encompasses the sex with which one identifies as opposed to the sex that's on one's birth certificate. So that would certainly be the kind of issue that could very well be litigated under the on account of sex language under the ERA as well. And the OCR's guidelines could be an interesting data point in setting the terms for that interpretive discussion.
Under the current Illinois Constitution's ERA, what cases have been brought using that as the basis, and are any of them extremely important precedential cases?
I'm going to defer to David. I'm not aware.
I'm not aware either. I think that it certainly has an important symbolic effect, and that's something that we shouldn't underestimate with respect to the federal ERA as well. I think what Justice Ginsburg was saying when she pointed out that all post-war constitutions have enshrined the idea of men and women as equal citizens before the law is the very important symbolic effect that these kinds of constitutional clauses can have. Now, one doesn't want to, as it were, clutter up one's constitution with too many symbolic statements, but this one does seem perhaps worthy of inclusion for that reason, and I suspect that the one in Illinois' constitution, if nothing else, has had that kind of effect.
Mm-hmm. This is the question. If the ERA were to pass, would most of the federal complaints allege a violation of the ERA amendment rather than the Equal Protection Clause?
Well, I don't think you necessarily have to choose, right? You could just, throw it all out there and see what happens. But, I also think it would depend on the type of case and whether we're talking about individual discrimination or systemic discrimination. I think that's important to consider as well. It'd be interesting to see a case under the ERA. I think that'd have a lot of fun drafting that.
I think, the answer is both.
Yeah.
I have a question here on religion. How does the ERA interact with religious organizations, and would it apply to religious organizations?
Well, I'll just talk from a political viewpoint, and I'll let these guys respond on the legal viewpoint. I got that a lot with marriage equality, obviously, for lots of reasons. When doing this in the Senate, no religion organization, any way, shape, or form, weighed in. We had one group, the Illinois Family Institute, that weighs in, but it's much more of was not a religious base. It's sort of they're against any sort of perceived changes in changing anything that seems to do with social or cultural norms, period. It was no religious basis that anybody has ever made.
They have a lobbyist, by the way, who his business card says that he's the ambassador from God to the Illinois General Assembly.
Wow. So I agree with everything Heather just said, but there is often an undercurrent when these very conservative folks start talking about abortion rights and they talk about sexual orientation. There's for some legislators, there's this undercurrent of concern that maybe they'll hear from their colleagues at whatever church they belong to, because there's been this public narrative that somehow this will impact those issues. And of course, there's nothing in the language of the amendment that does that. So while I have yet to hear any of my colleagues refer to religion. I believe there's some undercurrent because on a local level, these folks are constantly afraid of what happens when they go to church on Sunday, if they do go to church on Sunday, and they're concerned about what people will say to them. And unfortunately, the average legislator only thinks as far as how they can avoid having debates with their own constituents on the street corner. So they don't want to do that, and so so there's an undercurrent that is not on top of the list.
Deanne, I have a question from someone who says, if the ERA were to pass, would firings by companies because people believe that somebody's inappropriately dressed, and I'm guessing inappropriately dressed may be wearing clothes that they might think would be more proper for someone of a different gender, would it be covered?
It's a great question. You know what? I mean, I again, to my point about ERA helping, I think the LGBT community, if someone was, dressed as someone perceived them to be of the opposite gender, I do think it would raise it because I think it all comes back to the language because of sex. And just to the point that was made earlier about whether a passage of ERA would have to do, how it would impact religion, you have to look at the language of the amendment, and just like you look at the language of Title VII. Title VII specifically identifies religion as one of the bases that it it protects, employment discrimination. Race, color, religion, sex, and national origin are what are specifically identified in Title VII. ERA specifically says sex. So had the legislature wanted to include the language of religion, they could have. They didn't. So I'd say no.
This is an interesting question. How is it possible that women's soccer players get paid $25,000 a year, men's soccer players earn over $100,000 a year on the national team, and wouldn't the ERA prohibit such inequality?
I don't think, though I could be wrong, that U.S. Soccer, which is the organization that fields those teams, is a governmental entity. I don't think it is. So the ERA would have no direct effect there.
Now, always believe you should have ruffles and flourishes at the beginning and the end of a program. There's a woman in the audience who was a public defender with me a long time ago, and I watched her try a lot of cases. She watched me try a lot of cases. She actually represented the only woman who was trying to pass the ERA who was indicted for bribery in Springfield. And I'd like to ask former Judge Sheila Murphy, I'm going to make, this is a dangerous thing because I'm going to give Sheila a microphone, but I think you could go back there, and if you want to describe how somebody gets charged with bribery trying to pass a federal constitutional amendment and what the outcome of the case was.
Wanda Brandstetter had a PhD from Denver University. She was born in Oklahoma, and she came to Chicago and married a wonderful guy, and they owned property in Lincoln Park and in the Dunes, but she had no knowledge at all about law. And so when the National Organization Women gathered all these people together to lobby, she was told that she should talk to the legislators and tell them that she'd work for them, that the Equal Rights Amendment was very important, and she'd work for them for a month or whatever, and also donate money. And she thought, wouldn't it be a good idea if I have my own cards, I'll put this on the card. She put it on her card, and a lot of the legislators thanked her and talked about it. But one, who was a one-term legislator from Pekin, Illinois, brought it right to George Ryan, who I think was the Speaker of the House, and he brought it to Ty Fainer, who was the attorney, and he brought it to the state's attorney of Sangamon County, and that was it. And we were on trial, and the only woman who just been appointed judge in Sangamon County. And just like you were describing, Phyllis Schlafly, she was there. Her husband had also graduated from Georgetown. She was not yet a lawyer, and because she was giving out all this stuff, and she had all these poor women who could hardly walk were the Eagle Forum. And what we did wrong is that we should have immediately gone to the media and said, look what they're trying to do. They're trying to stop the Equal Rights Amendment. Instead of that, we treated it like any criminal case. Don't talk to the press, so forth. So that's the worst thing. So when we do it this time, we should have legal...
What was the outcome of the trial?
The outcome of the trial was she was found not guilty of bribery, guilty of a misdemeanor. She got community service, but we got letters in the mail. How could you do this? You have stopped the ERA. We are afraid to know what they'll do with us.
Well, and that was one of the things that did have an impact on the final votes before the 82 deadline was this arrest. And I think that one of the things that it says is that as you get involved in this process, as lawyers, you know how to represent yourself before bodies, elected bodies or judicial bodies. I always say the difference between a legislative body and a judicial body is the oath of office of a judge is to be fair and impartial. The oath of office doesn't mention that for legislators. We can be biased, we can have our own beliefs, and so you need to be super careful when you talk with people about what it is that you're trying to communicate to them. And I always tell people that the three things you're out there to do if you try to influence somebody is educate them on the overall aspect of the issue you're interested in, just as we've done today on the ERA. The second is you've got to advocate for a specific policy or position, as we're doing here, passing the ERA. And the final thing is you have to have that solution solve a problem. And passage of the ERA definitely would solve a problem, fill in a lot of the cracks that are in the systems that we have here. I'd like to thank our panel for being here today. I want to thank Deanne Brown for her experience in all the courtrooms and representing all these great people. Representative Lou Lang for representing his district and representing all the people of the state of Illinois and trying to pass the ERA. Senator Heather Steans for her efforts in moving this and for being the principal sponsor of gay marriage, which I think was one of the great accomplishments of the last General Assembly. And to David Franklin, the Solicitor General of Illinois. For those of you at home or are watching this at a later date, please work, as the legislators have said, to make sure your legislators understand what's going on. And with that, Elizabeth Wells will do the final blessing.
A non-religious blessing.
Thank you so much. Thank you, Larry. Thank you all, our panelists. Great program. Thank you, the attendees, both for your attendance and for your questions. Also, thanks to people on the web. I want to put a special thanks out to my co-chair, Sharon Eisman, who did the lion's share of the lifting on this program. She did a great job. And I have not met her yet, but there is someone, I believe, out there, AJ Conroy.
Oh, she's here.
All right.
Yes. Thank you so much. AJ was very instrumental in helping us put together materials and get speakers and kind of work out the substance of the program. We really appreciate your help. Thank you. Also, I am tasked with letting you know that we really appreciate if you would complete the critique forms that the CBA provides. We have, if you need MCLE, those certificates will be at the desk on your way out. Very important, if you're online, there will be something you need to click on your computer to get your certificate. And last but not least, I've been asked to tell you that if you leave the room, there is a card, or will be cards on the table, you have them, for people to fill out if they're interested in the passage of the ERA. This card says Illinois should finally ratify the Equal Rights Amendment because, so you're invited to give your opinion and then give that back to AJ.
Yep, we'll send it to your representative to encourage your representative like Representative Lang told us to do.
Okay.
Yes.
Great. Okay, thank you again.
Thank you all.